The Voting Rights Act of 1965, Section 2.
This act was signed into law on August 6, 1965, by President Lyndon B. Johnson. It outlawed the discriminatory voting practices adopted in many southern states after the Civil War, including literacy tests as a prerequisite to voting. As part of the Great Society, this act to enforce the 15th Amendment to the Constitution was signed into law 95 years after the amendment was ratified.
The Voting Rights Act of 1965, Section 2, key points.
Prohibition of discrimination. It bans any voting standard or procedure that denies or abridges the right to vote. Vote dilution. It is commonly used to challenge redistricting maps, racial gerrymandering that dilute the voting power of minority communities. Totality of circumstances. Courts determine violations by examining the totality of circumstances, including a history of discrimination, racial polarization in elections, and the ability of minorities to elect candidates. Permanent provision. Unlike some temporary provisions of the Voting Rights Act, Section 2 is permanent and applies nationwide. Legal standards. Based on Thornburg v. Gingles, 1986, challengers often must show that a minority group is large, geographically compact, and politically cohesive, and that the white majority votes together to defeat the minority's preferred candidate. Summation. Following a 2026 Supreme Court decision, the application of Section 2 is undergoing changes, with stricter requirements for proving intentional discrimination. Section 2 stood as a permanent provision for 61 years. The legal precedent set by this Supreme Court of the United States sets the stage for re-implementation. If it can be removed, it thus can be restored.
The Voting Rights Act of 1965, Section 2, key points.